You know that we don't catch that fishing boat? There ain't gonna be no deep sea fishing. We'll have to stay on the dock with the old people here. Hold it. What are you doing here? What? What about the other foot? There ain't no sock on it. I'll get to it. Don't you know that the whole world puts on a sock and a sock and a shoe and a shoe? I like to take care of one foot at a time. That's the dumbest thing I ever heard in my life. It's just as quick my way. Wait a minute, that ain't the point. You see what I don't keep doing it. Listen to me. Suppose there's a fire in the house and you gotta run for your life. Your way, all you got on is one shoe and a sock. My way, you got on a sock and a sock. You see, you're even. Suppose it's raining or snowing outside. Your way, with a sock on each foot, my feet would get wet. My way, with a sock and a shoe on one foot, I could hop around and stay dry.
From the Roundtable at Uncle's Studios in beautiful Southern California, welcome to another edition of Work Comp Matters, the central location for all you employees, employers, and independent contractors. My name is Steve Appel, and I'll be your host for the next hour with some talk, some news, and hopefully some answers about Work Comp Matters. Thanks for being part of the show, and if you can break away from your Work Comp Matters, feel free to give us a call and clue us in with your questions, comments, and or concerns. The phone number worldwide, 818-357-4120. You can send an email to wcexaminer@aol.com. You can be old school. Send me a fax, 818-475-1437. With me in studio, my right-hand man, Mike Zyma, my protege, attorney Robert Ozeron, Scott Walton on the board, my special guest, attorney Barbara Thompson, back in Munich, Germany, attorney John Scalia, and back at Work Comp Central, making sure the whole damn thing goes right, is Jake Paris. Well, good evening, everybody, and welcome to another edition of Work Comp Matters. We're talking about mediation, and we're going to get to our guest in a moment. Of course, as always, we're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system in the Kuiper Belt, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day. A1 Law. And of course, if you want those hard-to-get, sold-out, even front row concert, sports, and theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. Hello, everybody. I hope you had a great weekend and a great Father's Day. I wanted to take just a moment out and give props, give thanks, give love, as always, to both my kids, but especially my daughter, Lauren. She sent me a Father's Day gift and card which says, "Love you. Thanks always for teaching me to express myself." And then what do I get? I get the Rad Cat Dictionary of F word. We all know what that is. And essentially what this is as follows. The F word has livened many arguments and acts of sexual intercourse throughout history, easily ranking as the most celebrated, bleeped out, and dynamic of vulgar words in existence. It can be used as a verb, a noun, an adjective, an interjection, adverb, and with some imagination can probably work out for other types of grammar. It ranges in meaning from having phenomenally rigorous sex to showing sadness and dismay when life doesn't quite go your way. You can effing say F yeah to a person you effed last year who you now refer to as an effing effer. It really is a magical world. Anyways, the book's about 12 pages, and I don't know if it's for sale or whatever, but it's wonderful, and sweetheart, I love you. Now let's go ahead and get to our guest. My guest received her undergraduate degree from the University of California, Irvine in 1979 and her Juris Doctorate from the Pepperdine School of Law in Malibu in 1989. She was admitted to the State Bar of California in 1989. She has spent much of her legal career handling all aspects of workers' compensation matters, representing the interests of both applicants and employers. She also practiced employment and labor law for major institutional clients in both state and federal courts and Workers' Compensation Appeals Board. Since joining her current firm, and she can tell you about that, she defends all aspects of workers' compensation claims, including defense of serious and willful actions, 132A, coverage issues, subrogation. She has received her LLM in Alternative Dispute Resolution from the University of Southern California in Los Angeles last month, May. I would like to give a warm welcome to attorney Barbara Thompson.
Thank you, Steve.
The pleasure's mine. Thanks for coming on in, spending your valuable time with us. We've got a lot of questions to ask you, and of course, we are going to get to the news after we talk to a little bit about Barbara. We've got stuff about marijuana is being legalized in Canada. There's a decline in smoking. We've got President Trump and Space Force. We've got something with the Los Angeles jail. We've got something with Sepulveda Avenue and Pacific Coast Highway I want to get to, and more good stuff on Work Comp Matters. But let's see, Barb. The first question that I want to ask you is, when did you decide that you wanted to be a mediator?
I'm not sure that I can put a definitive time on that, Steve. It's a tough question to answer with when. I think going over the course of my practice the last 11 years as an applicant's attorney, I'd had many days in which I showed up at the board feeling fully prepared to do the best that I could for my client, to emphasize my skills in order to get everything that my applicant was due. I had many days where I would walk away feeling no matter what I did, I still could not, no matter how good my litigation skills were, do the best I could for my client.
Isn't that the old premise about the best settlements are where both parties walk away feeling like they gave up a little too much?
I don't know that that's actually what that premise is a good premise. I like to think, now that I've been educated in mediation, that the best settlement in mediation is both parties walk away with a settlement that they feel good about, because they've crafted that settlement themselves, as opposed to a settlement that both parties do not feel good about.
You know, in doing my research, because up until like a month or two ago, you and I had never really met. We haven't had cases together. We've both been doing this for 25 or 30 years. And so I met you, and then when I was telling everybody, hey, Barbara's coming on, not only did a lot of people know you, but everybody that I met likes you.
Thank you, Steve. I appreciate you sharing that with me.
You know, I'm the first one to say, okay, I like to think I know what I'm doing. I know I'm well respected, but there are people out there that just don't like me because, maybe I'm fighting tooth and nail for my client. Maybe I have a tendency to be a little short. Everybody I spoke to likes you.
How many people did you speak to, Steve?
I like to think that I do my research well.
Thank you.
What do you think is the most important thing that you learned in mediation school?
I think the most important thing that I learned is that a mediator needs to be educated.
Do you have to be an expert on the topic you're mediating?
I think it depends upon the nature of the mediation. I think being an expert, so to speak, is incredibly helpful. However, I think a mediator that is well-trained and well-versed in the fine details of being a mediator can turn around and mediate almost anything. And by way of example, one of the training tools that we've been utilizing is mediating in small claims court. And I'm part of the Los Angeles County volunteer mediator program for the small claims court and also the unlawful detainer. This is a situation in which we have zero expertise as to the subject matter. Most notably in small claims court, when we go in, we can encounter any variety of topics, and mostly claims in which the plaintiffs are bringing claims that really have no legal bearing and no basis. And if you can mediate something like that by skills of what you've learned as a mediator, you can mediate almost anything.
Now, you know as well as I do that in the Workers' Compensation Appeals Board, it's a very small community. We're seeing the same people day in and day out. And when you deal with the same people, you're dealing face-to-face, either in the courtroom, in the hallway, you're walking out for a cup of coffee. Day one in mediator school, do they teach you, okay, one party is in one closed room, the other party is in another closed room, and then the mediator walks back and forth and the parties never see each other except at the start and at the end?
No. The premise is, and the untrained mediator may wind up doing that, shuttle diplomacy. But the premise is that the beauty of mediation is that the parties can craft the mechanism of the mediation in any way they choose. I will say that in terms of the shuttle diplomacy with the parties never seeing eye to eye, that's something that has developed on the West Coast. On the East Coast, if you speak to a mediator, they would be shocked to know that most cases in California, at least in the civil arena in which mediation has been conducted for a number of years, we have the shuttle diplomacy. On the East Coast, they have something called a joint session in which the parties can, at that point, sit and speak to each other and address each other. We find that that is very, very helpful for parties that have issues and things that cannot be discussed and remedied through the course of the normal litigated case. There are interests at times when someone just wants to hear, "I'm sorry," that's something that's important to be able to have in a joint session. So I, as a mediator, have the attitude of I'd like to speak to the parties beforehand, determine whether the issues and interests allow me to have both parties in the same room, and allow each party to speak to the other, if that is something that is helpful to the parties. If it's not, then we do the separate caucuses.
That sounds awesome. My name is Steve Appel. You're dialed into Work Comp Matters. We're with our special guest, mediator attorney Barbara Thompson. We're going to have more questions and more answers for her. But right now, it's time for some news. Up with the first story of the night. He's my right-hand man. He keeps me in check and hopefully out of trouble, at least 90% of the time, Mr. Mike Zyma.
Thank you, Steve. I try. President Trump signed an executive order today regarding the administration's zero-tolerance policy amid nationwide outcry for the Trump White House to roll back the practice of family separation at the U.S. border. Signing the order in the Oval Office, Mr. Trump told reporters in the room that the administration would still continue its zero-tolerance policy while managing to solve the issue of family separation. Quote, "We are keeping families together, and this will solve that problem. At the time, we are keeping a very powerful border, and it continues to be a zero tolerance. We have zero tolerance for people that enter our country illegally," end quote.
Cigarette smoking is on decline and dropped by over 2% in the U.S. last year, according to figures published by the government. According to a report by USA Today, last year about 14% of adults in the United States were smokers, down from about 16% the year before. K. Michael Cummings of the Tobacco Research Program at Medical University of South Carolina said that while the change is not much, everything is pointed in the right direction. As the figures released by the Centers for Disease Control and Prevention, there are still more than 30 million adult smokers in the U.S.
And you know something, I wonder, and I'll throw it out to the table here. Who thinks a contributing factor to the lessening of cigarette smoke has to do with increased vaping and increased legalized marijuana smoking? I think that's a huge contributor to people smoking less. But, then again...
I would probably not agree. I would think that people who smoke marijuana and smoke cigarettes probably smoke both more because they're smoking all the time.
All right. Hey, Barbara, you want to read the next news story?
I sure will, Steve. Thank you. President Donald Trump voiced support on Monday for a, quote, space force, end quote, a sixth branch of the United States military that would be focused on all matters off-world. I'm hereby directing the Department of Defense and Pentagon to immediately begin the process necessary to establish a space force as the sixth branch of the armed forces. That's a big statement. Trump said in remarks to the National Space Council. We are going to have the Air Force and we are going to have the Space Force separate but equal.
In a decision that may have wide-range effect on California employers, the California Supreme Court last week ruled that negligent hiring can be considered an occurrence. The coverage case made its way to the state's highest court when the Ninth Circuit Court of Appeal asked it to certify a question because the law in California was not settled on the issue. The question: when a third party sues an employer for the negligence hiring, retention, and supervision of an employee who intentionally injured the third party, does the suit allege an occurrence under the employer's commercial general liability policy? The Supreme Court found that the answer turns on whether the injury can be considered accidental. The decision said Caroline Hurtado Ford, an Orange County-based lawyer in the litigation practice group at Haynes and Boone, has significant ramifications for California employers. You're dialed into WorkCom Matters. We're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out, even front-row concert, sports, and theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. My special guest tonight is mediator attorney Barbara Thompson. Barbara, what's the difference between arbitration and mediation?
Huge difference, Steve. I'm glad you asked me that question. Mediation, the mediator has no power whatsoever to render a decision. The mediator is simply a facilitator of the agreement that is crafted by the parties. There is no binding resolution at all unless the parties agree to a binding resolution. Arbitration is simply a paid-for-hire judge. Arbitration is a proceeding in which the evidence is presented, the witnesses give testimony, and the arbitrator renders a final and binding decision. So you may as well go in front of a judge if you're going to go to an arbitrator.
And I was going to ask you, because we have no rules for mediation in workers' compensation. However, when I heard about the services you offer, which essentially you come into the applicant attorney's office, your services are paid for by the defense, I figure, hey, I've got nothing to lose. To me, it's like an informal conference, and it's in my office. I don't have to travel anywhere. It gets me and the defense attorney together to hopefully work things out. So I'm all for that, and I back that 100%. How has the reaction in the community been to you going out and marketing yourself, both on the defense and the applicant side?
Well, I think thus far the community has responded in a very positive manner.
Excellent.
Everyone is on board to let's try this, but there are always hesitation. The hesitation is, can I get the insurance carrier on board? Can I get my applicant to agree? Well, I don't think this case is really ready for it. And well, we haven't done this in our system, and I'm just fine as it is, to which are all issues and responses that I feel that there is a counter response as to why mediation should take place, as opposed to just going along in the system as we know it.
Now, one question I've been waiting to ask you ever since you agreed to come on is talking about future medical care, because I have found that in our workers' compensation system, defendants recently have been offering to pay less and less for future medical care. However, the way I see it, I've been asking more and more. Now, I know why the defendants are saying they're basically using the excuse that everything goes through UR and that everything's going to be denied and you don't have to spend as much now as you do before. My response is, well, hey, if I dispute just 2 treatments in a year, you, defendant, are going to have to pay about $1,100 for your cost for IMR, and that is without paying a single dollar in treatment. So if my client, let's say, has a 30-year life expectancy, and I just IMR twice during those 30 years, once each year, that's $30,000 in in future medical expense before you pay a single dollar for treatment. What do you think about negotiating future medical care? How do you judge that? If you're a mediator, what are your opinions that you throw in?
Well, first of all, I as a mediator do not have an opinion that needs to be thrown into the table, because unless the parties ask me, my role as a mediator is to be a facilitator for the parties to craft their own terms. If the parties ask me to take the stance of being an evaluator, that's when I would step in and look at both sides of the situation and give them my frank opinion as to why your position is strong, your position is weak, and what my thoughts are if this case were to go in front of a WCJ.
Well, firstly, as you well know, the judges have no jurisdiction over settlement, but I would like your frank opinion. What's your take on settlements on future medical care?
I mean, my frank opinion on settlements is future medical care in terms of my mediator's perspective.
No,
or
compromise and release. As a defense attorney.
As a defense attorney, I frankly am all for settling out future medical care. Most of my carrier clients want to close their books. They want to move on to the next.
However,
case.
I'm sure your clients, they're going to look at the last 3 years of treatment. They're going to see maybe one or two less than $5,000 for the last 3 years. And I've got a guy with a 30-year life expectancy, and they're offering me $7,500. And I'm saying, no, let's go ahead and administer the file for the next 30 years.
Sure, but it's my job as a defense attorney to counsel my client to see the realities as to what the future medical care really can wind up costing you. Not to mention the fact that we have UR now, we have IMR now, we have that program for now. We don't know how much longer that program will last and if the pendulum will swing the other way in terms of medical treatment in our system. Nothing's a guarantee in terms of how future medical care will occur in the future. When I was an applicant's attorney, I would tell all of my applicants that settled by way of stipulated award, you have future medical care in compliance with the law that exists at the time that your doctor requests that medical treatment.
And those are all good points from my guest, mediator, attorney, Barbara Thompson. My name is Steve Appel. You're listening to Work Comp Matters. One of our regular contributors to the show is a 45-year workers' compensation attorney, and he's hanging out in Munich, Germany for about the past 4 or 5 years with his segment on mediation, attorney John Scalia.
Hi, this is John with the Work Comp International Report from Munich. When Steve informed me that the topic for this week was mediation, I immediately thought, what do I know about mediation? I'm a litigator. I try cases. And I've pretty much confined my practice for most of 45 years to one area of law. But then I thought about it for a while and I realized, John, when you've done something for that long, you probably have some relevant experience. And indeed, I do. When the Workers' Compensation Appeals Board was overwhelmed with its caseload a number of years, maybe even decades past, they set up a program of judge pro tems. Well, you really weren't a judge pro tem because you didn't have the ability to try a case. You didn't have the ability to issue orders unless the parties stipulated that you could sign an order. You were really a mediator. What that meant was that the parties came to you and hopefully resolved the case by settlement. Otherwise, they procured a trial date. Let's go back for a little history. What exactly is mediation? Well, it comes from the Latin word mediare, meaning to halve or to cut in half or to make half. In other words, compromise. Yeah, the old Jesuit education always comes in. The reason Jesuit grads do so well on vocabulary tests is that after 4 years of Latin and 2 years of Greek, you know all the difficult words they try to trick you with. The one thing that always gets me is, why is my Italian accent still better than my German accent, even though I've lived here for almost 5 years? But that really has nothing to do with the subject. Okay, so mediation is an attempt to get the parties to resolve a case, even though you personally don't really have any binding authority. What are the keys to effective mediation in workers' comp and probably in anything? 1, know the attorneys. 2, know the facts and the law. 3, know the unique problems that each side has, and 4, ultimately give your opinion and recommendation, and hopefully the parties will take it under advisement and settle the case. Knowing the attorneys in workers' compensation is fairly easy. It's a small community, and we all know each other. So once I received the cases, I looked at who was appearing for the defendant and who was appearing for the injured worker. I could immediately tell whether or not there was a possibility of settlement because we all know each other. Further, one of the advantages I brought to the table was that I've represented all the parties in the system. For over a decade, I've represented injured workers, I've represented management and self-insureds, and even represented medical groups. So I don't have any necessary biases or unnecessary biases coming into a case. What I do know as a result of that are the unique problems that each side faces in their case. I understand what their difficulties are. So once I know the facts and the law, I can look at them in the eye and say, well, this is the problem you have, Mr. Applicant Attorney, or this is the problem you have, Ms. Defense Attorney, or this is the problem you have, Hearing Rep. And then after I do all that, I can say, well, what would be a reasonable resolution of the case? And I make a suggestion to the parties as to what I think a reasonable resolution would be. Hopefully, I've done my work well, and hopefully they've believed that my analysis is correct, and they go in the hall and settle the case. And that indeed happened a fair number of times. So that's the key to mediation. It's a useful tool, and when it's done right, it settles cases. That's the view from Munich this week.
And John, all good points. Thank you, my man. Appreciate the contribution as usual. My name is Steve Appel. You're dialed into Work Comp Matters. We're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get concert, sports, theater tickets, yes, even front row, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. It's time for a little break, and we'll be back with our guest attorney, Barbara Thompson, after we hear something from La Familia, Glenn Laughlin, and the Cherry Blue Storms, Baby, You're a Rich Man.
How does it feel to be one of the beautiful people? Now that you know who you are, what do you want to be? Have you traveled very far, far as the eye can see? Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do. How does it feel to be one of the beautiful people? How often have you been there? Enough to know. What did you see when you were there? Nothing that doesn't show. Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do. Baby, you're a rich man. feel to be one of the beautiful people.
Glenn Lachlan and the Cherry Blue Storms with Baby You're a Rich Man. My name is Steve Appel, and we've got our special guest, mediator, attorney Barbara Thompson. So how's everything going at the firm you're at?
Everything's going very well at the firm I'm at.
That's great. They have no problem with you getting mediation assignments, that it's going to take time away from your billing or anything like that?
They are absolutely 100% behind my mediation efforts. In fact, the firm sent out a statewide blast indicating that I was available to mediate, and we'll take it from there.
You know, if I'm not mistaken, and of course I haven't given the name of the firm. That's up to you. You can if you want. You guys use A1 Law, don't you?
We sure do.
There you. Okay, how do you like A1 Law? Come on.
I love A1 Law. What did you expect me to say, Steve? I used A1 Law when I was with Gordon Edelstein et al. As well, and I'm quite familiar with it, and it's a fabulous program.
That's fantastic. Thank you. We're going to do a little news, and then we'll get back to Ms. Thompson. Mike, you've got the next news story.
Language in a confidential severance agreement Tesla Inc. is using as part of the biggest job cut in its history is likely to deter dismissed employees from going public with worker safety concerns, according to employment law experts. A proposed severance agreement Tesla presented to one of the more than 3,000 workers dismissed last week required acknowledgement that the employee, quote, had the opportunity to raise any safety concerns, safety complaints, or whistleblower activities against the company, and that if any safety concerns, safety complaints, or whistleblower activities were raised during your employment, they were addressed to your satisfaction, end quote. The document, obtained and reviewed by Bloomberg News, also barred the former worker from sharing business-related information, required that the ex-employee assist Tesla's defense against claims, released any claims made against Tesla, and dictated that any disputes under the agreement will be handled in individual arbitration.
Barbara was shaking her head during the reading of that story. You don't think that's a fair severance agreement?
No, and no.
Robert, you've got the next news story.
Canadian Prime Minister Justin Trudeau announced today that marijuana would be legal across his country, Canada, this year, October 17th. Canada's Senate on yesterday passed the federal government's historic bill legalizing the recreational use of marijuana, clearing the way for the country to become the first advanced industrialized nation to legalize the drug nationwide, and fulfilling a major campaign promise of Trudeau.
A controversial $2.2 billion plan to replace the overcrowded, crumbling men's central jail downtown cleared its last procedural hurdle Tuesday, when the LA County Board of Supervisors unanimously approved the project's budget and certified its environmental impact report. The Consolidated Correctional Treatment Facility, as the new lockup will be known, will be designated specifically to provide treatment and rehabilitation of medically and mentally ill inmates who make up an estimated 70% of the county's overall jail population, according to the LA County Sheriff Department officials.
Our next story is near and dear to my heart. El Segundo is pushing ahead with plans to rename Sepulveda Boulevard Pacific Coast Highway as part of a destination marketing push to give the city a more coastal feel. At yesterday's meeting, the city council decided to initiate the name change process without conducting a new round of surveys with businesses on the 2-mile stretch of Highway 1 that bisects the town, something that produced mixed results in 2014. Okay, I'm going to say this. Pacific Coast Highway is not Sepulveda Boulevard, and Sepulveda Boulevard is not Pacific Coast Highway, okay? It's sort of like you can dress up a pig so much, but it's not going to be like a dove or whatever. Now, Sepulveda Boulevard has always been known, and it probably still is, as the longest running street in Los Angeles County. I mean, it pretty much starts like all the way south at LA County and runs for miles and miles and miles. And if you ask me, I say the thing is totally ridiculous. Barbara, what do you think?
I agree. It's totally ridiculous. Pacific Coast Highway, as you said, is Pacific Coast Highway. And not to mention the fact that people will be immensely confused once they're traveling, and all of the Uber drivers in this town will be causing more of a traffic backup than as presently is, because they just won't know where they're going.
As a defense attorney, when you're consulting with your client with how much to settle, how much into account do you and your client take expenses? Like I was talking about the IMR cost earlier, which is really an expense rather than a medical benefit. You know, the cost of defense, etc. How much is that taken into consideration when you talk about settlement?
Well, I think the answer to that question is the same as the answer to the question of each individual applicant is an individual case that cannot be lumped into one category. It's the same answer in terms of taking into account costs. I think each and every single case has its own unique characteristics, and each and every single claims examiner and defense counsel have a different approach. So I think that's an impossible question to answer on a general basis.
Barbara, I have a question. What if in a mediation you note that you have recalcitrant parties, that is, parties that are just dug in to their position, and or parties that just hate each other?
Well, that's a compound question to start off with, Mike. But if I have parties, first of all, that hate each other, I think the issue that I raised earlier about whether we're going to have a joint caucus or whether we're going to have separate caucuses is something that needs to be addressed. Ideally, I would have the opportunity to meet with each of the parties prior to the mediation and assess what emotions there are at play to determine whether I'm going to have joint session and then break out in separate sessions. In terms of the first part of your question, when you asked what happens when there is an impasse, that's my situation in terms of, as a mediator, to come in with a reality check. At that juncture, I would ideally ask the parties for their permission for me to come in and take the role of an evaluator as opposed to as a facilitator. In my role as an evaluator, in order to break impasse, I give the parties a reality check as to what their case would look like if it were to go in front of a judge.
So each mediation is different too, just like what you were saying before about the cases.
Absolutely, absolutely. Each mediation has the various parties in terms of the applicant, in terms of the defendant, in terms of the personality of the counsel, and each has to be taken on its own accord.
Is there a value that that's a standard for a case that goes to mediation for workers' comp, or is there no limit? I mean, I'm thinking of a lower limit. In fact, it's like 20 grand is probably not worth mediation, right? So is every case 6 figures and above in front of you? Is that how it works?
Well, I think the answer to that question, Robert, is not specifically what the actual value is, but what the issue is. And I think mediation can be done at various stages of cases, and again, depending upon the nature of the case. And I was actually thinking about this issue prior to coming here today, and my thought process was, for example, if we have a good faith personnel defense action and we have a large corporation in which there are numerous witnesses on behalf of the employer, there is an employee that perhaps has been a long-term employee, there are emotions that are flaring, and we're in the 90-day denial period. I think a case in a situation like that, I think a mediation during the terms of the 90-day denial period in order to smooth over, resolve the case, and effectively put the employees and the business back to the practice of what they are doing for their work.
That is, when I was preparing for the show, I was thinking of using your services at the time the case was ready to settle. But depending on the issues, you're saying you might want to use your services during the first 90 days to get the case going in the right direction.
Yes, you may want to do that because we, as you know, in the defense business, we spend money in the first 90 days for our Labor Code 4060 compensability reports. We usually wind up having to pick up compensability, and the case goes on. Why not take that 90-day period, put the case into mediation, resolve, come to terms with something that both parties are happy with and close the books. Move on to the next case.
Robert, did you have a follow-up? Or
Well, to settle a case early like that would probably happen without medical reports, right? During the delay period?
Well, and correct me if I'm wrong, I don't think you were talking about settlement, although it's certainly always possible to explore, but you were just talking about getting the case going in the right direction, down the right road, right?
I'm talking about both. And we all, I shouldn't say we all, but most of us that practice in this field can take a situation, assess it, and give a reasonable estimate as to what the medical reports will say and what the whole person impairment and the permanent disability will be. We can all give that estimate.
But early in cases, insurance companies would probably be hesitant to offer something significant, right? So there'd probably be a large impasse between the parties.
Well, we're not necessarily talking about something significant. Again, it all depends upon the nature of the claim.
Excellent point. And my name is Steve Appel. You're dialed into Work Comp Matters with our special guest, attorney mediator Barbara Thompson. We're brought to you by A1 Law and Santa Monica Tickets. It's time for another musical break, and then we'll be back with some more news and some questions and answers for Barbara after a song from Susan Scheller.
I sold my soul, I can't get it back. I've fallen down on my lonely track. Something inside is dying to break free. I got chains from wings used to be. I long to break free from this lonesome jubilee. I feel so scarred, it's gone by this party's policy. Yeah. You know, if I could change my ways, baby, I would change today. I got chains, the wings used to be. Going high up in the sky. Don't worry, my life ain't gonna pass me by. Untold, I got chains the wings used to be. And just the other night, you know, I found myself talking to Jesus. I whimpered, why did well do I changed? And he said, you're gonna ride for free as long as you stick with me. I've been down, but it don't bother me, no. You know I had me some chains where some wings used to be. And he told me just like this. You're going high up in the sky. Don't worry, your life ain't gonna pass you by. It was looking like the end of the road. The lonely road, the dreams untold. You had chains, the wings used to be. Hang on now. You're going high up in the sky. Don't worry, your life ain't gonna pass you by. It's the end of the road, your lonely road of dreams untold. You got chains wings used to be. I don't mean to sound corrupt, but I've fallen, now I can't get up. I don't mean to sound depraved, not a straight line to my grave. Chains, wings used to be. I got chains where wings used to be. Something inside was dying to break free. I had chains where wings used to be. I learned you gotta keep changing. Take it from me.
and the sweet folk rock sounds of Susan Scheller on Work Comp Matters. My name is Steve Appel. We're brought to you by A1 Law and Santa Monica Tickets. We've got our special guest, attorney, mediator, Barbara Thompson. And let's see. I know I have another question. Or what do you say to someone who says, "Why do I need you? That's what judges are for."
Good question, Steve. Why do you need me? Because I allow you to come up with creative solutions where a judge does not allow you to come up with a creative solution. I also allow you to have a confidential situation. I also allow you to set your own rules. I also allow you to craft your terms.
That's interesting. You said confidential situation. So, I know what the word means, but can you be more specific about confidential? In other words, it's an informal settlement conference, right, with a mediator, or?
No, the two are very different.
Please explain, please.
An informal settlement conference is essentially the parties getting together and trying to resolve the thing themselves. There is no confidentiality involved. In a mediation, the parties will sign a confidentiality agreement prior to the mediation starting. That simply means that what is stated during the course of that mediation cannot be used in the further litigation of the claim. And the parties I am not allowed to share from individual caucuses between what one party says to me and another states to me unless a party specifically requests that I divulge a certain piece of information. It is of utmost confidentiality in mediation. There is no such animal in an informal settlement conference, and there is no such method in front of a judge.
You know, speaking of that, Mike and I were having a discussion a couple of days ago about being in camera with a judge, and you were just talking about confidentiality. Have you ever had an issue where someone was asking or petitioned for production of documents, or what someone said or conveyed to you or one of your clients, you felt it was privileged, and then you ended up before a judge who said, "Let's go in camera, let's talk about it," and then the judge will issue the decision?
I haven't had that instance happen to me in the field of workers' compensation, but I have a background in practicing in civil litigation, and that happens very, very often.
Can you give an example of besides documents? Because I know I know of in-camera inspection of documents, and then we have a situation I would think where an attorney might not be sure if something is privileged. They may have called the bar hotline to ask for advice. What have you experienced?
Oh, that's a difficult question, Steve, because I'm not sure that I've experienced that fact pattern that you've just put in front of me. I do know that in camera I have not used in workers' compensation. Have you had an opportunity to use an in-camera situation in workers' compensation?
Once in 25 years. It just happened last week.
But it resulted in settlement.
That's why, Mike, I will explain it. Okay, I was down at the board, and I had a client who wanted to settle his case quickly. He did not want to attend any more medical examinations. He wanted to move out of state, and we were settling the case clearly for much less than it was worth. The defense attorney and I go in, and we're trying to sell the settlement to the judge, and I can clearly see, without the judge saying, that he knew that the case, we were settling it for less than its true value. And the judge asked me, he goes, "So is your client working for another employer, or what's going on?" And I hummed and hawed, and I said, "Judge, you know, I don't feel comfortable." And he goes, would you like defense attorney to step out? And I said, "Judge, if it's okay with him, it's okay with me." And he goes, "Mr. Defense Attorney, with your permission, I can have an in-camera discussion with Mr. Appel." And the first thing the defense attorney, he looked at him like, "What, you going to do ex parte?" There was about a 5-second pause, and the judge looks at him and says, "I'm trying to approve your CNR." And so then all of a sudden the light bulb went on. He walked out. I was with the judge alone for about 90 seconds. I explained the situation. He then said, "Fine." We opened up the door, and he signed the order approving. That was really like the first time in 25 years I had ever done anything like that.
Congratulations, Steve.
Well, there's different ways to skin a cat. Go ahead, Mike.
Absolutely.
I have a question about the LLM program at USC. And I know that you got through it pretty quickly. It must have been an intense 1 year. Can you describe the LLM program in alternative dispute resolution, I assume is the...
Correct. What in particular would you like me to describe about it, Mike?
What were the course titles, for example?
A variety. But to address your point about me getting through it very quickly in a year, the program was started, that was the inaugural year of the LLM program in ADR at USC. And the premise behind it was to have the program be tailored towards working attorneys. And I can get into another area. There was another subspecialty that was for non-attorneys to train in ADR as well. But it was basically to be geared towards the working professional, to be taken either on a full-time basis or taken on a part-time basis. When I initially found out that I had been accepted to the program, I had considered part-time, thinking I'd be a crazy woman to go full-time and work full-time at the same time. But due to my attitude of there's not much that I can't do, I decided to opt to do the program within a year. It was a 24-unit program, and most of the classes started mid-afternoon and ended in the evenings. And to answer your question in terms of the courses that we took basic courses in the theory behind mediation, behind negotiation, behind arbitration, behind alternate dispute resolution as a whole. We had several courses in which we address cognitive biases that most of us walk around with being absolutely unaware of.
Tell me some of those cognitive biases.
For example,
Thank you.
I will give you an instance that happened to me in front of a workers' compensation appeals board judge. I had an instance of an injured worker who had had 2 stipulated awards that had been signed off in, I think they were in 2002 and 2005. They were fairly low value percentages. They may have been somewhere in the neighborhood of 11%, 15% each. This individual called my office to say that he had some questions dealing with future medical care, and my assistant happened to mention something about the payment for the stipulated awards, to which his response was, "What payment? I didn't know I got paid as well as being afforded future medical care." To which ensued a situation in which my injured worker told us that he had never been paid these stipulated awards. He then turned around and did a search of all of his banking records, produced documentation that did not evidence anything that looked fairly remotely close to a workers' compensation permanent disability payment or any lump sums that were near the amount of the percentage value. To which my client insisted that he was never paid, although the benefit printout from the defendant showed payment. We went in front of the judge. I was set at MSC. Oh, I take that back. I was set in trial in front of a judge that was set to leave the Marina Board that following month. So he just wanted to hear what the parties' arguments were. I had said to him, "Your Honor, my client will get on the stand and testify that he does not recall ever receiving such amounts. He is a meticulous individual, he has well-kept records, and his memory is good." To which the judge's response was, "Ms. Thompson, I'm sure I'm going to rule against your client. I can't remember what I had for lunch yesterday, much less your client remembering that he did not receive these payments." That was a cognitive bias. That was a bias that the judge pulled subconsciously from his own experience, that his memory is poor, and transferred that onto his thought process as to what my client could testify to and couldn't testify to. That is something that as a mediator and as a neutral, we work very hard to take those biases that we come into subconsciously in the mediation situation.
So was there psychology, if you will, in the coursework there?
There was actually, we played a lot of games in which these things were brought out to us and which made us cognizant of these subconscious biases. There was a lot of talk, we had a lot of courses that dealt with dealing with relationships and drawing in interests and probing with the parties and asking questions, actively listening, and coming to conclusions as to what the true issue was and what was presenting the problem in terms of resolution of the claims.
Did you guys study body language?
We didn't do so much studying of body language. I think it was more of emphasis on active listening and probing questions that really allowed parties, especially in a confidential situation, to open up about what the interests are.
Once again, all good points. My name is Steve Appel. We've come to the end of another Work Comp Matters. I want to thank my very special guest, attorney mediator Barbara Thompson. Barbara, if you want, please tell the listeners how they can get a hold of you. Telephone, law firm, email, whatever you want to do.
You got to plug your business.
Yeah.
Yeah.
Robert always plugs
I
it.
plug my business every time. It's the only reason I'm here. Most of the time.
Exactly.
Right?
9999999.
You must have some other reason
Well,
why
okay.
you're
I'm friends
here.
with the guys, but yeah, go
I
for
can
it.
be found at Goldman, Magdalen, and Creekus in the Woodland Hills office. The main telephone number is area code 818-755-0444. I can also be reached via my cell phone at area code 310-749-9495. My email at Goldman, Magdalen, and Creekus is bthompson@gmklaw.com. I can also be reached through my personal email that many practitioners that know me well have a good laugh over my email, but it's easy to remember. It's PaliBarbie, PaliBarbie @mac.com. Just remember I live in Pacific Palisades, and my nickname is Barbie.
And I forgot, what computer management system do you use for work?
I use A1 Law.
There you go. And
thank you, Steve.
You're
The
welcome.
time went quickly, and there is so much more that I can share with mediation.
Well, hopefully you'll come back again at the end of the year or next year or something when we have a spot available for you. I'd love to have you again. That'd be awesome.
I would love to come again, and I invite each and every single one of the listeners to help me to put a fresh new outlook on the way that we handle our claims in the workers' compensation arena. I challenge each of you to pick one case and contact your opposing counsel and say, I think this case would do well with mediation.
We're hoping to see you soon, frankly.
Absolutely.
And
thank you, Mike.
And for the record, I've already referred Barbara 5 cases, and I fully intend to refer another 5.
Thank you, Steve.
The pleasure is mine. It's been a great show. What can I say? From my right hand man, Mike Zyma, attorney protege Robert Ozeron, Scott from Uncle Studios, my special guest attorney Barbara Thompson, back in Munich, Germany, attorney John Scalia, and of course we can never forget, and we always remember all of the good people back at Work Comp Central who continue to support and approve of Work Comp Matters, including, but not limited to, Leaf File and Jake Paris. My name is Steve Appel. We'll see you again next week for another edition of Work Comp Matters.